My name is Janet LeBeau. I'm a law clerk at Gluckstein's. I just like to say Richard is always a hard act to follow, but we will do our best. It takes 4 women.
Not normally it wouldn't take that much.
So as I was saying, my name is Janet LeBeau. I'm a law clerk at Gluckstein's. I work specifically on the medical negligence matters, and I'd like to first introduce our esteemed panel, and we will be discussing this very important topic. Let me introduce everybody first. Jan, at my far end here, is a senior associate at our firm, works primarily with medical malpractice files. Jan is also one of the authors of our newly unveiled After the Settlement Guide. Brenda is our marketing manager, but most importantly, as you've all heard, she's a former client who has experienced the litigation process with respect to her own birth trauma case, or her son's. Brenda is also one of the authors of our After the Settlement Guide, and in fact is the one who got us started on this very important pursuit, as she saw firsthand the need for this very important topic. And Sandra, who's in the middle there, is a senior estate lawyer with extensive experience in providing advice, guidance, and resources to guardians on their legal responsibilities and fiduciary obligations. So as I said, Jan and Brenda and me are all co-authors.
And Jessica.
I'm sorry, Jess and Jessica are all co-authors of our new After the Settlement Resource Guide. This guide came out of a real need to equip clients with something as they navigate their next steps after settling their case, and will be available on our website as a digital download. And I'd just like to say, personally, this is something that I feel very strongly about. I've been a law clerk in MedMal area for over 30 years, I'm going to say. And I've had many phone calls from clients 2 years after their case has settled to ask me what the hell's going on with this passing of accounts. If you could just imagine that, not ever having to file an income tax return and then somebody saying to you, please fill this all out and provide all the supporting documentation. And that's what these parents, guardians were facing, and I had no advice for them. I'd send them off to a trustee lawyer, but I did not know how to help them navigate through that process. And it was very distressing for me, incredibly distressing for these clients. So the very first question I'm going to start off with is Jan. To kick off our panel, Jan, would you explain what prompted the creation of the After Settlement Guide and the desire to tackle this issue at Risky Business?
So Janet's already started this off for us. We started to have conversations at our office, and importantly, because we have Brenda as a resource who is a guardian, and so we see firsthand what she's going through, what she has to manage, what happens. And it became abundantly clear, and Brenda's communicated to us, as Janet has, through their communities and past clients, that people weren't prepared for what was going to come after the process. And over my years at the firm, we've done a lot of management plans, guardianship applications. We've done lots of these for children, for incapable adults. And there were things that I realized I didn't know myself, and I wanted to better educate myself, and thought ultimately all personal injury lawyers, not just our firm, but other firms as well, are going to be better off knowing intimately what is involved after the process, because we can't just simply send our clients out into the world and say, okay, the case is done. And Gluckstein has prided itself for years to be this full circle care is what we talk about. And what that means to us is that when things do happen later, when issues come up, that we want to be there for our clients and want them to know that we do care about what happens, and we want them to have successful lives after their lawsuits. We talk about the excitement of settling a lawsuit and how all of a sudden these resources are going to be available to people and life will change. Therapies are going to be available. Attendant care is going to be available. All of these things. But in managing those funds, there is a lot involved. And not having been a guardian myself, I had a lot of questions for Brenda about what she has to do, what happens, how that all comes to be. And we had a really engaging discussion about involving our clients at the management plan stage, which we're going to talk a little bit more in this panel and what that involves. The lawyers in the room probably will have some idea about that, but also what it means for families after the fact. You know, Sandra's going to tackle some questions around what if there's changes? What do we do? The pandemic saw prices soar. What happens? There are all these things that happen that we want to leave people in a better position. And so what we did is we had our group, Jessica and myself, Brenda and Janet, we got together to brainstorm what's the information that clients are going to need, where can they go for this information? We have guides on other things that Gluckstein's done over the years, resources, so what are some funds from government sources to pay for things that clients need while they're going through the lawsuit. We have done these things in the past, and this just seemed like a gap. We didn't see anything out there from other firms, anyone else has done anything like this, and we thought, you know, everyone will be better off for this, not just our group, not just our firm. And so we really wanted to pull this together. So over the past 6 months, we've worked together to do this. There's QR codes on each of the tables that you can take a picture of to some of the tables. And for those that are online, it is available on our website. Just this week was published to the website, so it's brand new and available. And it does go through. It's created for clients primarily. I think lawyers will actually get a lot out of it as well, but primarily for clients. It's meant to be digestible, that they can read it and have a sense of what they're getting into at the settlement stage. So before the management plan, before the application for guardianship are done, they can read this guide so they understand what's going to happen. I personally also think it's really important, and I imagine Sandra would agree with this and Brenda as well, that guardians need to know what they're getting into before they agree to take on that role. It is not an easy role. It is not a rubber stamping, I'm the person who's going to control the money. That is not what it is. There are very specific requirements, legislated requirements, statutory, that they have to abide by. And we need to let them know what that's about. And it's also important in the creation of our management plans, or for those that don't know, how the money will be spent, to consult with our clients directly to know what they need, what they want. We also have medical reports and all kinds of other things that we're going to talk more about, but our clients need to be part of that discussion in how those funds will be used. So that's how it came about, and we're really hoping it's going to make a fundamental difference for our clients post-settlement.
So, Sandra, I have a question for you. What do you believe are the essential things guardians must be told when they take on the role of guardian property?
Thank you. Good afternoon, and thank you for having me today on this important topic. So whether being appointed under the Substitute Decisions Act, which governs adults, incapable adults, or the Children's Law Reform Act, which governs minor children, the same essential points apply, and I want to keep it very high level for you. It is important, and I believe, and Jan just touched on this, it's important to advise the proposed guardian of the obligations and responsibilities of the role before he or she seeks to be appointed and before they actually get appointed, rather than agreeing to after being appointed. The role of the guardian, and this is important, is one of a fiduciary. And it comes with obligations and responsibilities like a trustee. Depending on the value of the assets under management, the legislation does require a bond to be obtained, so be a guardianship bond. So at times you have to consider whether the proposed guardian actually would qualify for the bond. A guardian is court appointed in a judgment, and the judgment approves the management plan. And for those who don't know what the management plan is, essentially it's a document signed by the guardian, the proposed guardian, outlining all the expenses, liabilities, income, assets of the incapable person, and how they're going to manage those funds. And that then is approved by the court and attached to the judgment. And it also stipulates that the guardian has to account regularly for how they handle the money. It's important the guardian be involved, as Jan said, in preparing the management plan, which should be as detailed as possible and to cover as many expenditures or eventualities. For example, if you're handling a settlement for a minor and that minor now has to use a wheelchair because of the injuries, consider the need in the management plan should cover things like the need for an accessible van and the cost of its maintenance. Consider extra costs for accessible vacations. Consider the cost of replacing and repairing the wheelchair. Once appointed by the court, the judgment binds the guardian to comply with the management plan and requires regularly passing of accounts. Now, this is a difficult tact for parents, I find, because this judgment with the management plan supersedes the decision-making power of a parent in a regular life. And parents have a hard time to separate themselves from that. And it's important to see that the parent must see themselves first as a guardian bound by the plan to handle these settlement funds over their decision-making as a parent and everyday use of money for the child. Now, the thing to understand as well is that there will be the permanent involvement of government agencies. So it'll be the children's lawyer for minors, and it'll be the public guardian trustee for adults, incapable adults. Therefore, the guardian will be under scrutiny and oversight of the court and either the OCL or the PGT. Lastly, and this is the real stellar or deal breaker for some guardians, is that the guardian could be financially responsible for consequences of not handling the money properly and not being able to account. So they personally have to go into their pocket and pay back whatever money they can't account for or not complying with the management plan. Thank you.
Brenda, what was the experience like transitioning from a litigation guardian in a lawsuit to a guardian of property?
So I got to keep this clean. So, and I want to
I know what her answers are going to be. So,
and I want to preface this by saying that Sandra has helped me through 2 passing of the accounts. So she's had the benefit of getting the venting.
I got the unclean version. Yeah.
She did get the unclean version both times. So it's hard, and you just touched on it right there. So, you know, when I decided to have kids, I decided to be a parent. And even that sometimes I'm not always sure of. And then, you know, you end up in this unfortunate situation where, you know, you have a child who has been impacted by medical negligence or otherwise, and now you find yourself in a situation where you are in this sort of legal, you know, guardianship situation. And, you know, that's not in any of the parenting books. It's not in any of the guides anywhere that you read. And so it's a difficult transition. You know, I am my son's mom. That is my job. I want to make sure he's happy and cared for and loved and taken care of. And those things are all super important in wearing this other hat as well. But as Sandra said, it comes with a different level of responsibility. It comes with a different level of financial responsibility. And, you know, when we are utilizing the funds for him that have been outlined and they're very clearly stated as to what they have to be and how they have to be utilized, that's a lot of responsibility for a parent. It's a lot to manage. It's a lot to think about, you know, right at the time of settlement as well as into all the years that follow. And again, it's not something you're ever prepared for. And even all these years down the road, I'm still not prepared for it. I still struggle every time we go through it. So the transition is hard because there's no way to get ready for that. And also, it's very emotional. You know, I am now having to justify and be responsible for the financial decisions that I'm making for my son because of this plan. And, you know, very rarely do parents ever get taken to task for the things you decide for your kids, right? They want to go here, you take them there. They want you to buy them this, you buy them that. And all of a sudden now you're in a situation where you have to justify the purchase of the wheelchair and the type of wheelchair that you got and the type of van that you got and an accessible vacation. And are you sure you need another hospital bed? Like you just got one 5 years ago. And all of these things that, you know, again, now you feel like you're being judged. You feel like you have to report to a higher body. And as Sandra said, I'm legally responsible. And so if, you know, something goes awry or something is not, you know, something isn't accounted for in the way that they're looking for it to be accounted for, that's, you know, my financial responsibility. So it's a lot. I just want to be his mom. And that, again, is my primary goal. And when you have to be a mom, a therapist, an advocate, and now also, you know, a legal guardian of his settlement, it's a lot. And I consider myself someone who's very articulate and informed, and, you know, I'm a pretty strong personality. And I struggle for families who are not in that same situation, who may have a language barrier, who may be newcomers to this country, who don't have that same level of confidence in how they manage this, because I think they really, really struggle. Mm-hmm. It's a big transition that no one prepares you for.
Right. So Sandra, to follow up on that, when you have guardians approach you for the first passing of account, particularly those that were not assisted by an estate lawyer during the initial stages, what are the common issues or concerns that you have found? Brenda touched on some, but what have you come across?
So I've kept it to 4, the main 4 that would apply to personal injury lawyers who I find may help a guardian put together a plan and a judgment. So the first is, the worst is, quite frankly, ignorance on the obligation to account. Guardian had no clue they had to account. The second is, to that would be the ignorance on the importance of record keeping if they did know they had to account, and failing to maintain proper records, and therefore they cannot account. I've seen accounts where the C word shows up everywhere. It's the cash, using cash. Stay away from the C word, especially with no receipts. So again, a guardian has to come out of their own pocket and pay it back if they can't explain what it was for. In one situation, personal injury lawyer in particular helped this person become guardian for their spouse who was in a car accident in a coma, and she was financially dependent by the spouse and her child. So there was a language barrier. She came for her first passing, and we realized she had no idea she had to account. She did not understand what the management plan was talking about. And she then thought that the money was like joint account, like we always had together. And she's there cashing things out, paying for things in cash to get no tax payments, cash and all that. And so then fear and panic set in, and here she is drawing in the personal injury lawyer to fix it all. And so here we are spending more money trying to get the personal injury lawyer to assist, explain, trying to get these records in order to do something with the PGT and get these accounts passed. Never mind if she gets removed as guardian. So in that situation, the guardian looked to the personal injury lawyer to fix it. And I spent a lot of time, as I said, with the personal injury lawyer and the law clerk who helped with the management plan to get everything organized. The third is failing to abide by the management plan that the guardian apparently signed. This is seen frequently where the guardian was not involved in preparing the management plan, and the management plan maybe doesn't reflect the reality, doesn't reflect all the information that's needed to manage the property properly. In some situations where you apply to be a guardian for an adult, you may not be privy to all their financial information, like their liabilities, assets, expenses. So sometimes we see that not a temporary, but a management plan will be signed based on information that the guardian has at the time. Once they're appointed, they then have the authority to get the information they need, so financial disclosure, to then prepare a better, more thorough financial management plan. And therefore, the judgment that appoints the guardian will then say you have to file an amended management plan within X number of months. And sometimes that's not done. So we then, as a state lawyer, have to come in and file that amended management plan with the court of the PGT. So the suggestions to avoid these problems. So let's talk about the management plan. Everything starts and ends with the management plan. So I want to emphasize that you have to emphasize that if the expenditure is not listed, you don't have money to spend on it. While you're entitled to it at law as well, the guardian is entitled to compensation, and it's dealt with at a passing of accounts. I would still include it as an expenditure on the management plan because it gives you a realistic idea of how this money is going to be used and what you have to work with. Think of every possible scenario or expenditure to cover. I appreciate that's ideal, but it should be something really thought through and confer with third parties who provide services. Most legal fees incurred in obtaining the guardianship and the passing of accounts are paid from the property at issue. So now the money is being depleted more. And if you're not aware, the costs are pursuant to Tariff C under the Rules of Civil Procedure. Once the litigation is settled and the amount of funds is fixed, the guardian is stuck with that amount of money. So all expenses relating to the guardianship are paid, as I said, from the capable person's funds, the application, the passing of accounts, and the amendments, which deplete the funds further. So if possible, for you as personal injury lawyers, I suggest, if possible, is that at the settlement phase or as you're negotiating a settlement, is to actually have a sum assigned or what I'm ahead of damages for the actual cost of a guardianship application and the subsequent passings. If the person's a minor until 18, every 2 to 3 years of passings have to occur, or if an adult until If that's possible, then I would put a head of damages, as I said, in the settlement, because of the injury, this guardianship is required. And as I said, the tariff C are the preliminary costs that are incurred in a passing of accounts that range between $2,500 to $7,500. Now, keeping these factors at the forefront will turn everyone's mind to the realities of a guardianship. And if you need to, the other thing is to obviously amend the management plan if there's changes or if required by judgment. And how to amend the management plan, I'll touch upon this later as well, is if it's for an adult incapable person, you would amend under the SDA, and you could proceed to amend before the court in a motion, or you can negotiate the amendment directly with the PGT. I have comments on that. Practical speaking, I can speak to you about that later. If for a minor under the CLRA, the amendment is to be approved by the court on notice to the OCL, as well as on notice to the PGT for an adult. And it's realistic to expect to amend the management plan at some point. So hopefully it's not because of errors or oversights initially. And the accounting, let's talk about the accounting. Provide information on what an accounting looks like and emphasize the importance of record keeping from the outset. Ideally, to connect the guardian. So if they're appointed guardian, they understand the management plan, they understand they need to account, I would suggest connecting that guardian to an estate bookkeeper, and it's a specific person, an estate bookkeeper who's only does passing of accounts. And they would tell you how to put them in, what records to keep, and that would get them moving towards success at the next passing of accounts. And if you know, the passing of accounts are pursuant to Rule 7418 of the Rules of Procedure. So while it may seem initially to have the personal injury lawyer prepare the application to save costs, they may be spending more later to correct errors and expose the guardian to financial consequences. So it's best to retain the estate lawyer with experience with guardianships. The guardian can keep the costs down if you do retain an estate lawyer, because the guardian will be the person who will be doing the management plan. I go to the guardian to tell me the information to go into a management plan, and that's where most of the expenses are incurred, is to prepare a detailed and thorough management plan. Thank you.
Thanks, Sandra.
So Jan, and Sandra's already talked about a lot of this, but what situations do you engage an estate lawyer in preparation of an application for guardianship and the creation of a management plan?
So Sandra and I talked about this when we were planning our panel, because, she had sort of questioned, estate lawyers should always be involved, and why wouldn't they be? Why wouldn't they be? And I had to, talk about the realities of the other side of practice, which is the cost involved at that stage, and that it is very common in the personal injury world for the personal injury firm and lawyers to prepare the management plan and to prepare the application for guardianship. That is something we've done many, many times. And so when would we consider bringing in an estate lawyer? When should we consider bringing in an estate lawyer? These are slightly different questions, right? And, what do I use as a guiding compass in terms of making that decision and talking to my client about it? Of course, that you need your client's instructions in that regard to tell them about what an estate lawyer can bring to the table, the costs that might be involved in that. But what are the considerations? Number one is complexity, because dependent upon how much funds are coming in, dependent upon how many needs your client has, these are going to be things that you need to consider. Some examples of times when we've engaged estate lawyers, so in situations, they're rare, but when they occur where you need a corporate guardian as one of the guardians, it might be a co-guardianship situation, you probably want to consider bringing an estate lawyer. It adds considerable complexity, considerable cost, but there are families who having a parent or a grandparent, even an aunt or uncle, a close family member be a guardian isn't a workable situation. It isn't for everyone. And while that does come with considerable cost, it needs to be considered in some situations. And those situations may be some where you really do need to get an estate lawyer involved because of what's going to come with that. Thinking about the differences between children versus adults. Sandra touched on this, but with our minor clients, the money that's coming in, it's primarily the medical needs. There may be, of course, money also for ultimately their losses of income as they become an adult. But in terms of the under 18 time period, the costs that need to be outlaid by the guardian for that child are the medical needs. The parents still remain responsible for the usual costs of living, their home, food, general recreation, not the additional costs that somebody with special needs may require. But there aren't a ton of liabilities with kids, right? When you're dealing with a guardianship for an adult, considerable complexity can be added. And Sandra's situation, when we were talking about it, really brought that home for me too, in a situation where a breadwinner has a brain injury. All of their money is now subject to a management plan. The couple may have had a single account and made decisions about purchasing or selling a home, assets that they were jointly managing together, and all of a sudden, those decisions are no longer the personal decisions of the spouse, and they're subject to a management plan. That is incredibly complicated, and really those situations, I would feel very strongly that I'd want to bring in an estate lawyer in that kind of situation to ensure that those funds are managed appropriately. There may be complexities with purchasing of homes as well. So I had a situation a number of years ago where a significant sum of money was being paid for a modified home, and the family's plan was to modify to some degree a current home they were living in and then move to a home they were building. Well, what do we do with that money in the meantime? How are we going to deal with this? This was an incredibly complex situation where we essentially set up a mortgage in the name of the minor, because banks, by the way, won't mortgage homes that have a minor listed as an owner on the home. And it was so complicated. Within a year, we had to amend it again in order for the money to be transferred to the new home that wasn't going to have a mortgage on it for a variety of reasons. And at that point, the child could be listed as having an interest in the home. But these kinds of situations, retrospectively, the amount of hours I spent on that situation, and others in the office assisted with that case as well, really from the beginning would have been an excellent situation to bring an estate lawyer in, because it was so complicated. And I really think we need to think about this in terms of our obligations to our clients as well. The law is becoming more and more specialized. Each area has so many nuances, and our clients are going to be well served by bringing in experts from whatever area that's necessary, or at least consulting with them. So in the event that your firm does decide to prepare the materials, maybe the decision is made that you consult with an estate lawyer, get an opinion, and pay for a limited amount of time or a review of the materials. These are some creative ideas potentially that you can get that expertise without having a huge expense. And then in our guide, one of the recommendations we made to our clients and others is that after the management plan and everything's put together, you might want to have an initial consultation with an estate lawyer about your obligations. We put some ideas in there, what Sandra mentioned in terms of how to manage funds, not to use cash, to have an Excel document you're creating to manage and come up with all the things you've spent your money on so you don't have to recreate the wheel down the road. But Sandra has a list of bookkeepers she provides her clients. I don't have that. And so that's a resource for our clients to send them to someone like Sandra, say, pay for a couple of hours of her time, and you will be far better off moving into the future and managing your child or loved one's funds.
So Brenda, what advice would you give to a new guardian?
So I would say, assuming that we're at a place where clients are being informed of the things that they're going to need to be aware of, and that they've been involved with the management plan and they're very comfortable with that, and they've looked over what those expenditures are going to look like, and all of assuming all of that is equal. There's two really key things that sort of came to mind for me. And the one was, and you've both touched on it, is the importance of being organized. And I can't stress that enough. And I don't just mean organized in the sense of, your spreadsheets and things like that, but really organized. You have to know everything about that expenditure to the best of your knowledge. And, as an example, I often will advise people who have come to me and sort of said, what have you figured out? We keep detailed spreadsheets. And in the spreadsheet, aside from the date and the expenditure, why did I spend this money? Why was it important? Why did we feel that we had to do that? There's situations where, again, you touched on this, where, when we settled our case a number of years ago, the cost of PSW support is not what the cost of PSW support is today. It doesn't change the amount of support that we require, and as he gets older, I need more support as he gets bigger and heavier. But it's important for me to make a note of that. I need to talk about, here's what we were, here was the cost before, here's the cost now. This is why, even over COVID, we had an extraordinary amount of hours because he was being schooled online. I still had to work. And so, keeping those notes, because when you go to pass the accounts 2 years later, your memory is not great. And it makes it much easier when the estate lawyer is helping you to pass this information along through to the children's lawyer, to whoever that might be, that you have these detailed records. So I tell people, be as organized as you can, not only with your receipt keeping, but the actual retelling of why you have spent that kind of money. The second, well, there's actually not too much. The other one is ask questions. Ask as many questions as you need to. Ask questions, where you can. Understand the management plan. Understand the expenditures. Ask questions about, what might need to be seen when you're passing the account. Ask as many questions as possible. There's no stupid question. There's no stupid answer. It will just help you as you're moving through this process. And I say reach out to as many people as you need to get those answers. And the third thing is it's not personal. And I need to advise parents to keep the emotions out of it. And I remember saying to Sandra very clearly when the responses came back from the children's lawyer on one of our initial submissions, and I said to her, well, you let them know I'll have his bags packed and they can pick him up at 2, and I'm happy for them to keep him. Because, it was so much work, it was so emotional. I felt like my parenting was being questioned. I felt like I was being judged as his mom. And that's not fun. I'm in a very highly charged situation as it is with a medically complex child. But the job of the OCT in this example is they have to protect the child. They have to protect those funds. They have to protect the way that they're spent, and this is their job. And it's important to understand, I think, as guardians going through this, that it is not personal. When I have conversations with Sandra where she's like, you need to do this, and this is why, I have to just not keep it personal. So I tell people that because if you can separate the emotion from the functionality of the role that you're playing, I think it really will make it a lot easier, and I think it will reduce the amount of anxiety and upset that comes with it.
And if I could just add, I've worked with many parents who have gone through this whole process. One of the things that they have said to me is that the Office of the Children's Lawyer or whoever they're dealing with doesn't realize the trauma that they had experienced with the birth and then the litigation, and then to have to go through it all again. So it's very difficult not to take it personally,
Right.
Because it's just one more thing that they're having to deal with. And when they're already dealing with PTSD. So this is my thought. So during the pandemic, we saw healthcare costs soar. We talked about the rising costs of PSWs and RNs. Guardians may not have enough funds to cover necessary care and may wish to use money allotted to recreation or other medical costs to cover an essential service like attendant care. How can a guardian best manage this difficult situation, Sandra?
So again, I'm going to say that we should comply with the management plan. And the first thing to determine here is whether this expense is a one-time expense or if it's going to be permanent increased expense, and the consequences are differently. So ideally, the management plan should consider the increased costs over time. So I usually put a range of costs for a particular service versus a fixed dollar amount. Let's say like $25 to $30 an hour for PSW versus $25 an hour. Again, this has to always come down to the amount of money available, right? They have to always balance out the expenses and the amount of income. I also include a miscellaneous expense, literally a miscellaneous expense category to draw from for reserves. We're not talking thousands of dollars. Again, it depends on what the amount of money available. It could be $500, it could be $1,000. And I've had clients draw from that where there's deficiencies in other categories. So the starting point is to comply with the management plan because, again, the guardian exposes him or herself to personal liability if not. The onus is, in this situation then for changes, the onus is on the guardian to show the increased expense and why it has to be incurred. And that has to be presented, and it has to be in the best interest of the incapable person. So if the expenses are needed, the guardian, I do this, is that the guardian through me, notifies the PGT or the OCL immediately of the circumstances, the change of circumstance and expenses, and whether it's a temporary solution or permanent, or it's a temporary issue or a permanent issue, and the solution put forward in the meantime, okay, until we get the other things done. And how, so the temporary solution, how covering those costs in the meantime, and advise of the intention to amend the management plan. So, how to pay for the additional costs? This is the question. So I've had different scenarios. So first of all, at the end of the day, you have a fixed amount of money. So that's what we're working with. So I've had situations where a guardian or parent, if it's not the same person, covers the additional costs and then seeks reimbursement from on a passing or when the management plan is being amended. While not ideal, you could take from unused portions of funds. So if you have an expense for a category like, I don't know,
Therapy.
3 vacations a year, you didn't use it. So you could take from that pool of funds to temporarily pay for this expense, because ideally at the end of the day, the expenditures are still the total same. So if you're taking the 1,000 from this category, putting it to this, it's not more money you're spending, you're just shifting the money over to other categories. So at the end of the day, you're not spending more, and that the money spent is in line with the management plan. And then the thing is, too, practically speaking, you have to keep all documents relating to this expense. Again, why needed more? Have you got competitive rates? What's the best figure to put forward to the PGT? And to keep this information for the next passing or for when you're seeking to amend the management plan to reflect this permanent change. And if it's a one-time additional expense if it's not a one-time additional expense and then you need to amend the management plan, as stated before, you have to provide the evidence of this expense. So I've contacted PSW companies to get their rates to see what's the better rate to put forward. And as I said earlier, if it's for an incapable adult, you have 2 options under the SDA. You either do a motion to the court and seek approval of the amended management plan on notice to the PGT, or you negotiate directly with the PGT and they stamp it, signed if it's approved. If it's for the minor under the CLRA, you have to go through the court on notice to the OCL. Again, the costs of all this is, again, from the fixed amount of money. And it's to also be approved on the next passing. Thank you.
Jan, when you're working with clients to create a management plan, how do you balance the competing needs when the settlement funds do not fully cover the care recommended in the future care cost report?
So, as we know, when we settle these cases, and most of them are settled, you're making a compromise for the most part. And so you may have put forth many millions of dollars to cover future care, all different categories. And when it comes to creating a management plan, there's not enough for the total amount that's been recommended by your future care providers. And so what do? I would be remiss if I didn't mention that there can be a bit of a conflict in your parents that you're working with and the kids' needs. Parents want maybe more attendant care. The child maybe would benefit from future medical care. And while parents, of course, always have their kids' best interests in mind, we have to satisfy, as the lawyers, the children's lawyer, and ultimately the court, that these needs are needed. And again, we're having these conversations about the guide initially, and Brenda's so passionate about this topic, and there'd be a few times where I felt like the wet blanket lawyer, and I was like, okay, hear that, but I'm going to be going to the children's lawyer with this plan, and the children's lawyer may not see a recreation expense as necessary as some, as the wheelchair or as the physiotherapy or the occupational therapy. And we really have to consider these competing needs. So number one, what do your medical reports say? What do the treating doctors say? What are the things that are critical? That's important. You got to consider that. That stuff has to go in there. When you're thinking about attendant care, yes, a lot of our clients, especially in the medical negligence world, these are bigger cases. They require 24-hour attendant care. But the reality is, talk to your parents. Are you going to be home 99% of the time in the evenings? Yes. Okay, well, let's talk about respite care then for periods of time when you want to go on vacations and you need that nighttime care covered. So we don't need to have money allotted for 24 hours a day. Maybe it's 8, maybe it's 16, maybe there's somewhere compromise in between with some additional time as needed to be used for times when the parents do have things that they need to do. And these are the balancing things that we need to talk to our clients about. And then when we go to the OCL, many of times they've come back to us and said, well, that's not what the future care cost report said. And it can be frustrating, right? You've spent all this time putting it together, really thinking about what the needs are, where the money should be spent. And I find it in the same way Brenda mentioned, not to take it personal, I always remind myself, they are absolutely looking out for this minor. That is their primary goal. And it changes the dynamic for me when I'm having those conversations. And personally, I have great relationships with all of the lawyers at the Children's Law Office because I approach them with that in mind, that they're protecting my client, my minor client, who is very vulnerable. And there might be times where you need to take a lot of time to explain the decision making. And it goes back to some of the things the parents are going to be subject to at passing of accounts. You have to justify the decisions that you're making in these management plans. And there are times when, Brenda was talking about her family loves to camp. Well, McLean can't just go and stay in a tent in a campground. And so for their family, I hope you don't mind me talking about all this,
fine,
Brenda,
no,
a camper, they
don't love camping, just so McLean loves camping, but carry on.
But to bring McLean, it's a huge extra cost. And it is integral to his happiness. And so when you go to the OCL and you're talking about this, okay, is it a medical need? Well, arguably it's a mental health need. And so he wants to join his family. And there are ways of talking about some of these needs that we really need to think about and have the meetings with our clients and think about holistically what makes this person's life best. And it might be that over physiotherapy. It might be. And it's difficult. These aren't easy decisions. It's not easy to decide where the money goes. We don't know, in most cases, what things are going to cost or what the needs are going to be 30 years from now. We don't know. And that's where, there probably is going to need to be an amendment at some time in the future. We have a fixed amount of money, but needs may change. And these are things you have to think about. It's not easy, These aren't simple. There's a lot of gray involved in this, and we really need to think about all the people that are affected and how we're protecting our minor client.
And there will eventually be a new management plan. We're talking about minor children because once they turn 18, they no longer are governed under the CLRA. Mm-hmm. Then the guardian has to reapply to be appointed guardian under the Substance Decisions Act, and the whole process starts again. But hopefully by then, there's so much experience, and this management plan is perfectly situated to put it now under to the PGT and move forward that way. Yeah. And just to touch up on the note, though, I've had clients where I've a situation where there was a compromised birth, and this child is now 21, so he's been a huge settlement, supported. He could have anything he needs. There's no issue about money. But the parent, we were in court, and the parent was now the parents were now 5th time passing accounts. And the judge was like, I want a bond. And I'm like, they've passed their accounts 5 times. Do they really need a bond? Because the bond premiums come out of the money of the child. But this situation, the child could afford it. And the parent's like, who knows? Maybe the parent will divorce and the new wife will take the money. And I'm like, okay. So the parents at first, okay, fine, we'll get a bond. They were annoyed, but they said to me, we are so happy and relieved as parents that when we're no longer here to take care of our child, these rules are in place to protect our child. So we will do what they say, because who's going to replace us has to comply with these rules as well to protect our child.
Mm-hmm. So finally, Brenda, from the perspective of a former client and current guardian, what do you want the lawyers in the room and out there to know about your legal journey?
Oh boy. How much time do I have?
How much time does you have?
I'm only teasing.
We're out of time.
We're out of time.
We're already over time.
That's such a complicated question. Again, I'm just going to come back to a couple of pieces. None of us planned for this. We're unprepared for it. No one helped you with the transitions that you're going to go through. My relationship obviously turned out pretty good with the lawyers that assisted us in this case. And I'm thankful for that because there's a lot to navigate. The journey is complicated. The journey is complex. What comes after it is super complex. And really, I think, I think it's just important that we continue to make sure that we have resources and supports for our clients that are going through this, for any client that's going through this. And, we don't have to have all the answers. As lawyers, as, individuals in the room who are service providers or those other types of roles, your role is extremely vital in this journey. But we need to make sure that if we don't have that particular knowledge set, if we don't have that information that our client might need throughout this journey, that we find that for them and that we continue to find ways to support them. As we learn, we share those learnings, we share that knowledge with them, and we just, again, like I said, I think the more support that we can give, it's better for the parent, it's better for the child, the outcomes are better, and we hopefully will lessen, some of the challenges that people have. And I will say, anyone that's involved with future care planning and any of the lawyers that are involved with management plans is please think about these pieces. We're hopefully getting to a point where we're moving away from the strictly OT, PT pieces, and we're bringing in recreational therapy, and we're thinking about SLP, and we're thinking about all of those other things that are vitally important, if not more important, I would argue, in some of these cases. Because here's the thing. My son's going to get to a point where PT and OT is not as impactful or important for him as it was when he was 8, 9, 10, 6, early intervention. Things like speech therapy, things like augmentative communication, things like recreational opportunities, things like social experiences and building his social network and supporting his mental health. Those are extremely important. And we have to make sure that we are incorporating those. We're accounting for them, we're documenting them, we're allocating the funds for them so that it makes it much easier for those parents to have those funds, to not have to justify it, and that we're just looking at things in a more holistic way. And so that would be my advice out there, is that every case is unique, every case is different, and let's make sure that we have really taken a look at what is the best for this family and what is the best for this child in the capacity that we have.
And also, go onto our website and look at the guide.
And look at our guide.
Yes.
Thank you.
We all worked very hard at it. So
Yeah.
thank you, everybody.
Thank
and
you.
Thank you. And I think this is
Lunch.
Lunch?
Lunch.
So, there you go.